Okay. Okay, Assalamualaikum. Hi again. Okay, so now we are into our second part, whereby I will discuss on the contract of service. Okay, so you need to know the definition of contract of service as opposed to contract for service, and we are going to look at important statutory terms and conditions. Okay, contract of service will only come into the scene once you are hired. So once you are hired, okay, there will be a contract of service between you and your employer, either in writing or orally. Okay, as I said in a previous video, that oral contract of service is normally done in a small enterprises, small companies. Now, so however, it's still a contract. It's just that when you do not have your contract in writing, then what will happen when there is any dispute between you and your employer? Where do you fall back? Okay, so that is why it is advisable to have the contract of service in writing, and actually you do not have to go to lawyer. Okay, but if you want to, and if you want lawyer to draft your contract of service, by all means you can do so, but you have to pay them. Or if you work in a big company, normally the big company, they will have legal department, or so the legal department will get together with HR department and they will come up with a standard contract of service. Okay, so what is contract of service? Contract of service is someone, it is not an employee. Okay, for contract of service, let's say this is the employer and there must be employer and employee relationship. Okay, so the contract of service first will spell out, what is your job, the job title, the salary wise, and the hours of work, your off day, your rest day, and what other benefits that comes under your contract of service. Actually, there is no hard and fast rule how a contract of service should look like. It depends on individual companies. So as long as you have all the details that I mentioned. However, if you are protected under the Employment Act or under Sabah and Sarawak Labor Ordinance, which I'll brief you later, then if your contract of service is silent on certain matters, which is already provided by the statute, therefore the statute will override. The statute will prevail. In Malay, sekiranya kontrak perkhidmatan kamu tidak menyatakan apa-apa peruntukan, tapi peruntukan tersebut ada di dalam akta dan juga ordinan, maka peruntukan dalam akta kerja dan ordinan Sabah dan ordinan Sarawak tadi akan digunakan, akan mengatasi, will prevail. What about contract for service? Contract for service is, let's say, I give you an example. Let's say this is your company. So your company needs cleaner to clean the office. So, but you do not want to hire cleaner under your payroll, because if you hire cleaner under your payroll, that is under contract of service. So you have to train, you have to pay benefits and whatsoever to the cleaner. So let's say now you outsource. Now let's say you outsource the cleaning services to, let's say, ABC, cleaning services. So in these circumstances, between you and ABC cleaning services, there is a contract for service. ABC cleaning services is under contract for service with your company to clean your office. So ABC cleaning services may have cleaners. So it could be cleaner X, cleaner Y, cleaner Z, maybe this one is cleaner okay, let's say R. So between these cleaners and ABC cleaning services, there is contract of service here. So contract of service, okay. So meaning that X, Y, Z, R, they are an employee, okay, of ABC cleaning services. Between your company and ABC, which you outsource, okay, layman, they will say outsource, meaning that the ABC cleaning services, okay, there is contract for service, okay, between you, okay, the company, your company and ABC. But between ABC services and their cleaners, they are under contract of service here. Okay, so meaning that it is ABC cleaning services who have to train the cleaners, not you. Okay, if there is any, okay, statutory deduction, it is not you who will have to pay for X, Y, Z, and R. It will be their employer. Their employer is ABC Cleaning Services. But ABC Cleaning Services is under contract for service with your company. So ABC Cleaning Services can assign X, Y, Z, and R to clean your office. Okay. So this is the definition of contract of service. Okay, under Industrial Relations Act, it is known as contract of employment. So the term is interchangeable. Okay, so the keyword here, see, whether oral or in writing, whether express or implied. Okay, see, and the provision under Industrial Relations Act is also more similar whether oral or writing, express or implied. Oral I've already explained. What about express and implied? Express means that the terms that have already been, you have stated either on the paper, or you have expressed it verbally. Implied means that something that you have to read between the lines. You have to refer to the practices, yang tersurat dan yang tersirat. Express means tersurat. Implied means tersirat. You siratkan daripada apa yang telah berlaku dalam sebelum ini. Okay, what is the practices in your company pertaining to that matter? Okay, so that is why it is known as implied. Okay. So why do we need to differentiate contract of service and contract for service? First, employer has to pay compulsory statutory contributions and payment. So a statutory contribution here refers to, in Malaysia, EPF, SOCSO, and EIS, Employee Insurance Scheme, and also income tax for those who are taxable. Okay, employers will only be liable for torts committed by their employees in the course of the employment, which resulted in injuries or damages to third parties. So this is when an employee, while in the course of his duty, he caused an injury or fatal death to a third party. Therefore, the employer, is likely to be responsible for it. Let's say, I give you an example. Let's say a group of doctors performing an operation, and somehow, they have accidentally left, let's say, bandages, in the, in that person's body, So, and then it was later find out that, so the patient suffered, So, and then when they go, when the patient went for another checkup, that they find out that there is some, unknown item left behind. So this is based on actual occurrence, yeah. So the patient here, can sue, depending whether it is private or public hospital. If it is a private hospital, sue the hospital, sue the company that owns the hospital. So now let's say KPJ. So who owns KPJ? Who owns Gleneagles? Which company that owns Gleneagles and so you have to sue them. Don't sue the doctors. Whether the doctors can be sued or not depends on your lawyer's advice. So, and then for government's hospital, you will have to sue the government of Malaysia. The government of Malaysia, and then maybe the doctors maybe might be sued as well, but the ratio, I mean the percentage of the amount that they have to pay for the amount of compensation that they have to pay might be slightly lower, depending on, there are a lot of factors, okay, but on this, okay, that determine how much damages that need to be paid, okay. But what I'm trying to say is that, okay, it is the employer who will have to bear the responsibility, okay. Then employers owe duty of care at common law, okay, to their employees to take reasonable care for their safety while at work. So while while the employees are performing their job, the employers must make sure that they are safe, okay, meaning that if you noted that, okay, there is unsafe behavior or unsafe situation, therefore the employer should do something to stop employee from, okay, pursuing their work, okay. And employee will be governed by the provisions of respective statutes, okay. It depends, like, if, let's say, if the employee, therefore they have to pay tax, okay, they have to, okay, employer will have to deduct for their tax, okay, employer will have to contribute for their EPF. So like the example that I gave you just now, okay, the cleaners, okay, X, Y, Z, and R, they are not your company's, okay, employee. So you do not have to pay their, you do not have to deduct their SOCSO. You do not have to pay, you do not have to contribute for their EPF. So because they are not your employees. So who will have to contribute to their EPF? It is their employer. That is, in our example, in the last slide, the employer is ABC Cleaning Services. So the employer is the one who will contribute to the, okay, statutory deduction. And if there is a judgment against employee, employer can be compelled by the court to deduct employee salary to honor the judgment. So now let's say there is a judgment against your employee. So therefore, you okay, there will be an order for you to deduct to deduct the employee's pay for a certain amount for a certain period to pay the other party. For example, let's say in terms of monthly maintenance for children in the event of divorce. So let's say there is a court order that, okay, the father's salary will have to be deducted of a certain amount. Therefore, the employer for the husband, for the father, will have to abide to the order. So now let's say the employee, the father, okay, earns, let's say, okay, 5K a month. Okay, so then there is an order that he has to pay, let's say 1,000 a month for his 4 children. So here, okay, once there is an order, the order will be sent to the employer. So the employer will have to deduct 1,000 a month to pay for the maintenance of his children. Okay, but there must be court's order. Okay. Okay, vicarious liability. Okay, remember when I gave you an example of the negligence by the doctor, so which is known as medico-legal. Okay, medico-legal negligence. Okay, so in the case of medico-legal, okay, so now let's say, as I said to you just now, okay, so you have to check whether it is a private or it is a government hospital. You don't sue the doctors because doctors in private, they are highly paid. Okay, they can earn like 100K or even 200K a month. Okay, but if you are suing them for millions, they might not have the capability to pay millions. Okay, that is why, okay, the plaintiff means the one who start the civil suit. The plaintiff will have to sue the employer. Okay, similarly, if it's a government hospital, okay, then you sue the government of Malaysia. So here, employer will be liable, I explained just now. So as long as, okay, there is a duty of care and there is a breach of that duty and damages suffered. So the doctors, for example, while they are performing the operation, they owe duty of care to the patient. And when there is negligence, so it means that there is a breach of that duty and damages suffered, meaning that that patient suffer, okay, a lot of complication, maybe bleeding and so forth. So these are the elements that need to be proved in the event of, okay, if the plaintiff is suing under tort. Okay, when it comes to Malaysia, okay, when it comes to the terms and conditions, meaning that in terms of hours of work, in terms of notice, in terms of public, okay, work on public holiday, in terms of annual leave and so forth, they are known as terms and conditions. And in Malaysia, the terms and conditions are segregated according to the region. So Employment Act is applicable to Semenanjung, Malaysia, whereas Sarawak Labour Ordinance is applicable to Sarawak only, and Sabah Labour Ordinance is applicable to Sabah Labour. Sabah Labour Ordinance is applicable to Sabah. So there are 3 statutes governing terms and conditions of employment in Malaysia. Okay, so under Employment Act, okay, actually Employment Act is amended, yeah, in April 2022. It will come into force on the 1st of September 2022. So it is applicable to those, okay, in first schedule, that is those who are earning 2,000 and below. But we have to be careful on this, because there might be an order, okay, which will be issued by the minister that might, okay, change this. Okay, so as what I'm saying is that as of today is, okay, 14th of June. As of 14th of June 2022, okay, the first schedule spelled out for those who earn 2,000 and below. So things might change in this, okay, when in September, okay. So let's watch. You have to look for that as well, okay. And when it comes to Sabah and Sarawak Labour Ordinance, the threshold is 2005 and below. Okay, Employment Act. Okay, so okay, I'm explaining based on Employment Act because there is not much differences between Sabah Labour Ordinance and Sarawak Labour Ordinance. Okay, however, I will highlight should there is any differences. Why I use Employment Act? Because if you were to refer to the books are referring to Employment Act. Okay, so application of Employment Act. Okay, you have to understand the underlying principles of Employment Act. And okay, Section 7A says that more favorable terms are not prohibited, meaning that you can have, okay, you can have more favorable terms. Okay, let's say, for example, minimum annual leave in Malaysia for those who work less than 2 years, the minimum annual leave is 8 days per annum. Okay, for those who work less than 2 years. But should the employer, okay, let's say the employer would like to give 10 days. So 10 days are more favorable compared to the minimum terms of 8 days. So the employer is allowed to give, okay, to provide for 10 days annual leave because it is more favorable. However, the employer cannot give 6 days annual leave for those who work less than 2 years because it is less favorable. So less favorable terms, okay, shall be null and void. So therefore automatically the provision of the Employment Act pertaining to the annual leave will be applicable. Okay, another important features in Employment Act is that employer cannot prohibit an employee from joining a union. Okay, that is under Section 9. So it is totally up to them whether they want to join a union or JCC or whatsoever, because it is our guaranteed right in our federal constitution. Okay, and also, okay, we have to be careful with the definition of employees. So you can refer to Section 2 sub 1 and also the first schedule. And another features of Employment Act is that, okay, the provisions provided under Employment Act are only minimum provisions. Okay, meaning that you cannot go lower than that. Okay, so this is the definition of employee under Employment Act, and also similarly in Sabah and Sarawak Labour Ordinance. Okay, but as I said to you, okay, this is correct as of today, 14th of July. Okay, However, when the new amendment, okay, which will come on 1st September 2022, we will see whether the minister has makes changes to the schedule or not. As of today, the minister just said that they will change, they will amend the first schedule, but we don't know. Okay, we don't know for sure how it looks like. Okay, because why it is okay, why the minister is going to amend the first schedule. Okay, because why the minister did not bring the amendment to the definition, okay, when they table. Okay, that one I have no answer for that. But for your information, minister has the authority to amend the schedule, because schedule is within the purview of minister's duty. Okay, duty. So that is why minister can make the amendment, okay, to the first schedule. So we have to wait and see. So first, okay, irrespective of occupation, so regardless what is your job title, you can be a manager, you can be CEO or whatsoever, as long as, okay, your salary is semeranjung, as long as your salary is below than 2,000. However, if you're in Sabah and Sarawak, 2,500. Okay, then the second limb, okay, the first limb is irrespective of occupation, as long as the wages is, okay, 2,000, okay, and below. And in Sabah, 2,005, okay, for Sabah and Sarawak. And irrespective of wages. The second limb is concerning irrespective of wages. So it does not matter how much this employee earns, as long as he can be categorized as manual worker, or he can be categorized as those who work, or those engaged in vehicles to transport passenger or goods. Okay, passenger or goods, supervisor to the manual worker, and those engaged in any capacity in any vessel registered in Malaysia, and domestic servant. So I've already explained on this. Okay, remember I talked to you about contract of service. So this is the explanation. Okay. Now, who is a manual worker? So in the case of Vengataslam, Chalapan versus Federal Power, Sandhya Merhat, this is a High Court's decision. It was decided in 2019. Okay. The appellant, that is the complainant, had been a machine operator since 25th May 1981. Okay, with the respondent's company. So until the company decided to close down its operation in June 2017. So the appellant, okay, which is Vengataslam, was dissatisfied with the decision of Director of General of Labour, which dismissed, okay, his claims for termination benefits. Because, okay, if a company closes down its business, they have to pay termination benefits, okay, wages in lieu of notice and wages in lieu of annual leave, okay. If there is any, let's say, if, okay, let's say the annual leave is, let's say, 20 days. Okay, for that particular year, employee only use 10 days. So meaning that there is balance of 10 days. So in the event of winding up or closure of business, so company must pay, okay, the remaining annual leave, the remaining unused annual leave, and convert into monetary. Okay, so wages in lieu of annual leave and wages in lieu of notice. So similarly with notice. So now let's say if the company has to give 3 months notice, but the company only give 1 month notice, so meaning that there is remaining of 2 months notice unserved. So meaning that this 2 months notice must be paid in terms of money. Okay, so the issue here, whether the complainant fall under the category manual labor. So the High Court allowed the appellant, meaning that the court agreed that the appellant, that is Vengataslam, is a manual labor. So what is the ground? Okay, So the court said that being a machine operator, the complainant's complaint should be treated as one under subsection 69 sub 1 of Employment Act. And okay, it has to be read together with paragraph 2 of first schedule. Okay, therefore, okay, the manual labor extends to a supervisor as well. So the court said that it was wrong for the DGL, okay, the Director General of Labor, to decide that okay, the claim under section 69B, okay, is not applicable to Vengataslam because Vengataslam earned more than 2,000. Okay, so coming back to our previous slide, that respective of the title of the, respective of how much he earned, as long as he falls within the 5 category, there is manual worker, okay, those engaged in transportation, okay, to transport goods or passengers, or those manual, okay, supervisor to the manual workers, those who work in the vessel or domestic servants, so they can earn how much, but they are still protected under Employment Act. So that is why if you noted that those who operate the bulldozer, okay, the steamroll and so forth, they are the crane operator, they are highly paid. Okay, they are paid like, I don't know in Sabah, okay, but in Semenanjung they are paid like 200 ringgit, 300 ringgit per day. So obviously they earn more than the threshold. So, but because they fall under manual worker, so it does not matter how much they earn, they are still protected by the Employment Act. Okay, in the case of Colgate-Palmolive Malaysia, Sdn Bhd versus Cheong Wu Feng and 12 others. This is the case in 2002. Okay, the court said that okay, manual labor involves physical exertion as opposed to the mental or intellectual effort. So therefore, it is not manual labor if the real labor involved is labor of the brain and intelligence. Okay, so in these circumstances, in this case, there are technicians who wanted to be declared, they wanted to be declared as manual workers, okay, so that they can get protection under Employment Act. But their job, okay, because they are technicians, okay, yes, they do use their hands, okay, but they also use their brain. Okay, so when the court look at the nature of the technician's work, okay, the courts could say that they spend more than 50% of their working hours doing non-manual work. So meaning that this technician is not considered as manual workers. So they cannot get the protection under Employment Act if their salary is more than 2,000. Okay, so this is okay, similar decision in these cases, and you can refer to Donovan and Ho as well. Donovan and Ho really writes legal issue that suits non-law readers. Okay, so it's written for laymen. Now we're going to look at the terms of contract for employment. So these are the minimum terms incorporated in the Employment Act. So we're going to look at definition of wages, notice to terminate the contract, termination for misconduct, breach of contract, minimum days of work, payment of wages. Then, okay, working hours, rest day, and public holidays and annual leave. I will record in another video. This will be in the third video. Otherwise, this video gonna be very, very long. Okay, then you will fall to sleep. Okay. What is wages? So, what is wages? Okay, if you were to refer to the Employment Act, Section 2, wages means that basic wages and all other payments due under the contract of service, excluding these items. So meaning that when you do the calculation, okay, for the wages, okay, you have to exclude this because these are not considered, okay, under wages based on Employment Act. But if, so you have to be very careful if you're in charge of HR, because under EPF, wages may mean differently. Similarly, under SOCSO Act, similarly under Income Tax Act. So you have to look at, okay, which purpose are you calculating the wages? Is it for, okay, overtime purposes, or is it for income tax purposes, or is it for EPF purposes? So you have to be very careful with that. Now I'm going to brief you on the termination of contract. So the important term that you need to know is termination simplister and fixed term contract. Okay. Termination simplister means that termination which is done according to the notice. Okay, done according to the notice, but employer did not attach any reason. But employer did not attach any reason, any justifiable ground. So in Malaysia, you cannot do this. In Malaysia, you must, okay, for an employer to terminate an employee, you must give a very, very solid reason. That is why, okay, the selection point is very important, because once you have taken that person as your employee, okay, he will remain in your company until he resigns, okay, until he dies, or until he retires. Okay, so if if he doesn't want to resign, if he wants to continue working in your organization, you cannot do anything. You cannot just simply terminate him if his performance is good. If he does not, okay, he's not involved in any misconduct, you cannot terminate him. Okay, so that is why, okay, being a psychology student, okay, you should know that what are the traits that you need for your organization, what are the suitable employee for your organization, and whatever that you have learned today might not be relevant in few years time. So you have to keep on, okay, increasing your knowledge. You have to keep on, okay, reading, okay, so that, okay, you will, okay, so that you will be you will be okay, you're aware of what's going on, okay, in the industry. And when it comes to fixed term contract, this is very common. Nowadays fixed term contract is normally a 2 years or 3 years contract, 2 or 3 years contract, and then it is renewable depending upon the employer's discretion. Employer's discretion means budi bicara. Okay, so sometimes the employer still wants to renew, okay, the service of that the contract, okay, employee. However, the company, okay, lacks money, so okay, that is why, okay, the contract is not renewed. So this is, if that is the reason, okay, therefore the court, okay, if let's say if the employee is taking actions against the company for non-renewal, the court may, okay, ask the company to furnish the court with the financial statement. And if the court is satisfied that there is financial issue, then it is the prerogative of the company not to continue the service of the employee. Okay, but be very careful with fixed term contract. When someone is under fixed term contract, normally 6 months before the expiry of the contract, okay, that employee will have to write in to the employer to, okay, to show his intention that he would like to continue working with the company. And the company, okay, however, the company is not obliged to renew the contract. As I said, okay, there are a lot of reasons that need to be taken into account. However, at times, okay, it is the habit for the company to renew every 2 years or 3 years, they will continue automatically and so forth. But suddenly, okay, the company does not renew, okay, after so many years, okay. So you have to be very careful with this, okay. And another thing is that do not give hope to the to those who are under fixed term contract. Don't give hope to them that their contract will be renewed, because if you were to do so, then you did not renew the contract, then there is a basis for them to take actions against your company. Okay, notice to terminate the contract, okay, based on Section 12 of the Employment Act, either party So the word here is either party. To a contract of service may at any time give to the other party notice of his intention to terminate of such contract of service, meaning that either employer or employee, either party. Okay, however, if that is, okay, meaning that they can agree on, okay, the notice period. Let's say both parties, normally employer will be the one who will say, okay, your notice period is 1 month. Your notice period is 1 week. So if the company says that your notice period is 1 week, so you also must have one, okay, you must also have 1 week's notice, okay, in the event if you want to resign. So it has to be equal. Okay, but I have noted that some companies, when it comes to them terminating the employee, they terminate the employee within 24 hours. But when it comes to the employee who would like to leave the company, employee must give 1 month's notice. So that is null and void. Okay, employer 1 day notice or 24 hours lah. As opposed to employee, okay, 1 month's notice. So this is not valid. Yeah. So in this happen, okay, if this happen, therefore you will fall back upon the Employment Act or Sabah and Sarawak Labour Ordinance. So based on Sabah Labour Ordinance, Employment Act, Sabah and Sarawak Labour Ordinance, okay, the notice, let's say if there is no, both parties, okay, did not mention any notice period, therefore the provision in the Employment Act will be applicable. So for those who work less than 2 years, okay, the notice of resignation, okay, or the notice of termination must be not less than 4 weeks notice. For those who work 2 to 5 years, the notice required, okay, is not less than 6 weeks notice. And for those who work 5 years or more, okay, if employer would like to terminate them, but be very careful with this, employer must give 8 weeks notice. But if that employee who has served more than 5 years would like to leave the company, then they must give 8 weeks notice. Okay, but if they have already agreed on, let's say, 3 months period, therefore that 3 months is applicable. Okay. Now, what is this? Indemnity in lieu of notice. Remember just now, these are the notice period. Okay, these are the notice period. Okay, so now what happened if, okay, someone would like to leave immediately. Okay, so therefore he will give notice, but he did not wait for the notice to expire. Okay, or he simply does not give any notice at all. So you have to fall back upon what is the notice period? What is their notice period? Now, let me give an example. Now, let's say someone who has been working for 5 years. Now, let's say he would like to resign. Okay, so the law says that he has to give at least 8 weeks notice. So he will give 8 weeks notice, and upon the expiry of 8 weeks notice, only then he can leave the company. However, if he wants to leave immediately, he can do so, but he has to pay the company, okay, the salary equivalent to 8 weeks notice. On the other hand, let's say he gives notice, and the notice is 8 weeks, but upon serving 2 weeks notice, he wants to leave immediately. So meaning that there is a remaining of 6 weeks notice. So he has to pay the company, the indemnity means bayaran, indemnity, pampasan, indemnity in lieu of notice equivalent to 6 weeks. Okay, so we can do this, okay. Okay, so now Lily, okay, now let's do this. Okay, Lily, okay. So, okay, he earns 1,000, okay. Traveling allowance, okay, and, okay. So here, traveling allowance is not excluded, okay. And let me, see, traveling allowance is excluded from the wages. So when you, okay, in this situation, so meaning that her salary is 1,500, plus 150 because attendance allowance is not excluded, so it's therefore it is wages. So her salary is 1650, so this is below 2000. So she is an employee under Employment Act. So now she wants to resign. Okay, she wants to resign and the contract is silent. So if the contract is silent, therefore, she will have to fall back upon EA. So she has just started working, meaning that she has been working less than 2 years. Therefore, she has to give, 4 weeks notice. Either she gives 4 weeks notice or she pays, or pays indemnity equivalent to 4 weeks. Equivalent of to 4 weeks notice. If she pays indemnity to the company, she can leave immediately. Or if she served 4 weeks notice, but she did not wait for the notice to expire, therefore she has to pay the remaining, only work for 1 week. So 3 weeks balance. So this one, remaining unserved. So she has to pay, 3 weeks indemnity to the company. Okay, termination for misconduct. Okay, what is misconduct? Okay, meaning that an act which is inconsistent, um, which is against the company's rules and regulations. Okay, so however, the act here says due inquiry. Okay, but I don't have the time to explain to you in detail what due inquiry is. Okay, or it is also known as domestic inquiry. Or in Malay, it is known as siasatan dalaman. Okay, or we call it DI. Okay, so, let's say if there is misconduct, so you have to know whether it is major misconduct or minor misconduct. If it is major misconduct, then you have to go through the DI, and then, these are the punishment, meaning that dismissal, if you're going to dismiss, it has to be a very, very serious misconduct. Let's say, theft at the workplace or bribery. Okay, very, very serious. But you can also downgrade. Okay, meaning that let's say he is a senior executive, now becomes junior. Okay, or senior technician becomes junior technician, or impose any other punishment as the company deems fit. Okay, meaning that maybe any form of punishment may be, um, the bonus, is less or whatsoever. It's up to the company. Okay, so as I said, if you are going to convene a domestic inquiry, so you can suspend the employee who is alleged of committing misconduct, but the suspension must not be more than 2 weeks. So while during suspension, he will only be paid half pay. But if he's not been found guilty, therefore the company has to reimburse, the other half pay. Okay, breach of contract. Okay, an employer shall be deemed to have broken his contract if he fails to pay wages in accordance with Part 3, which I will come, later. So, for example, let's say salary must be paid to the employee not later than 7th day from the end of the wage period. So let's say your wage period is the last day of the month. So before the 7th day of the next month, employee must be paid. Now let's say, I know this is very rampant in small companies, in small enterprises. Sometimes they don't have money, so they say, oh, you take half first. Okay, we pay another, okay? So you pay half, or you only pay the employee in the middle of the month. So that is breach of contract on the part of the employer. What about the employee? An employee shall be deemed to have broken his contract of service with the employer if he has been continuously absent for more than 2 consecutive days. For more, meaning that 3 days consecutively, 3 days and above, without prior leave from his employer, unless he has a reasonable excuse for such absence and has informed or attempted to inform. attempted, ya, cuba untuk bagi tahu. Okay, but I think this clause has lost its clause, dah hilang taring, because nowadays everyone has mobile phone. Okay, those days, okay, we rely upon the public phone. Okay, so sometimes the public phone was not working. You know, there was a case that this estate workers, okay, he fell sick, so he wanted to inform his company that he was sick, cannot come to work. So he cycled to the nearest public phone. It's not working. Then he cycled to the next kampong, okay, to use the public phone, still not working. So he cannot afford to, I mean, he does not have energy anymore to cycle to the other kampong, so he went back. Then, okay, so he was absent for more than 2 days. Okay, so when he went back to work, okay, the company said, oh, you were absent, okay, for more than 2 consecutive days, so you are hereby terminated. But okay, so he went again, so he sued the employer, and he has testimony, okay, given by, okay, because by friends and relatives, that they can see that he was cycling, okay, trying to look for the phone, but the phone was not working. So the court held that, held means putuskan, the court held that, okay, the employer has acted, okay, and I mean the employer terminated him, okay, without justifiable ground, because he has made an attempt, okay, to contact the employer. And there is testimonies given that he did try to contact the employer. Okay, minimum days of work, okay, those in estate workers, okay, whether it's raining or not, okay, they will be protected, okay, they will get 24 days, okay, wages, okay, because prior to this provision, okay, the estate workers, they only get paid if they actually work. So what happened during the monsoon season? So that is why, due to the pressure from the NUPE, National Union of Plantation Employees, okay, therefore, okay, you have this section. So the companies, okay, have to be smart. They have to ask, I mean, they can allocate tasks for the estate workers to do when it is raining. So maybe clean the office, whatsoever. Okay, payment of wages. Okay, payment of wages. These are the, okay, payment must not be must not be later than 7 days from the last day of wage period. Okay, so payment of wages here, as you can see here, okay, this is, okay, quite a new case in 2019, Syarikat Logistik Peti Kemas Sdn Bhd versus Masri Halim. The plaintiff, okay, that is Masri Halim, okay, employees of the defendant, okay, they are lorry drivers. So they were not being paid minimum wage. At that time, the minimum wages was 900 ringgit. So the Director General allowed the plaintiff's claim and decided that, okay, uh, okay, decided that the plaintiffs were not paid the minimum wage by the defendant as provided. So the defendant, that is the company, dissatisfied with the Director of Labor's decision. Okay, so, okay, and the defendant, the company appealed to the High Court. However, the High Court dismissed the appeal. The High Court said that the minimum wage at that time was 900, therefore it is mandatory to pay minimum wage to the lorry drivers. Okay, the wage period is, okay, you have to agree, okay, the wage period, but it must not be 1 month. But in Malaysia, I noted that the wage period is based on calendar month. Okay, but in the UK, it will be based on monthly, on weekly, okay, or bi-weekly, meaning that once in a fortnight, okay. So you must pay before the 7th day after the end of the wage period. Advances, can employer give advances? Yes, you can, but the maximum is 1 month's salary. Why? Because if you give advances more than 1 month's salary, then the employer will have difficulty in getting back the money. And furthermore, okay, the employer, it can always deduct, but how much can you deduct? More than 50%? Cannot. Okay, so deduction should not be more than 50%. Okay, so I mean, let me rephrase. The employees must have at least 60% of their income in order for them to survive. Okay, so that is why. And what happened if the employee, okay, run away? Okay, how are you going to get back your money if you're the employer? And these are the examples, okay, situation whereby you don't have to pay wages for to the employee when the employee is being held in custody by the authorities. Let's say they are being held, okay, for drug possession, okay, or when they are in prison, or when they are required to attend a court hearing, okay. Let's say he is a witness of an accident, so he is, okay, required to attend the court, okay. So you don't have to pay, okay. Why? Because the, okay, let's say his service, okay, he is required to attend the court by the plaintiff, so the plaintiff will pay him, okay, how much, okay, how much he, I mean, how much salary that he lose for attending the court trial. So it will be paid by the plaintiff, or if it is the defendant that requires him to come to court, okay, to testify whatsoever, so the defendant will pay. However, if he has to go to court, okay, to become a witness for the employer, then employer, okay, must not deduct his salary. Okay, when it comes to the deduction, remember I told you just now that deduction must not exceed 50% of the salary include, okay. However, it does not, okay, housing loan is not taken into account. So let's say if someone's salary is 50, okay, let's say 1,800, therefore you must make sure that deduction should not be more than 900 a month, except for housing loan. Okay, because otherwise, how is he going to survive? Okay, and employer has the right to make certain deduction for recovery of wages overpaid immediately preceding 3 months prior to the month of deduction. Let's say employer wrongly paid. Okay, the employer overpay the employee. So employer can recover, but recover can only be done 3 months preceding the month of deduction. So now let's say you want to deduct the salary, okay, because you have overpaid, let's say overpaid 1,000 ringgit to this employee. So you cannot deduct one, okay, the whole amount, okay, so it has to be made in installment. So you cannot make, okay, the deduction can only be made 3 months preceding. So if it is in July, so in June, you can make deduction for the overpay amount for the month of June, for the month of May, and for the month of April. So if you have overpaid him since last year, then you cannot make deduction anymore. And of course, payment to the EPF, SOCSO, EIS, and IRB. Okay, wages must be paid through financial institution. Okay, however, if employee request for employees to pay by check, they can do so. Okay, and actually the law says that wages must be paid by legal tender, meaning like cash. However, upon request from the employee, employer may pay by check or by paying into employee's account at a financial institution, because it is very risky for the employer to carry a lot of cash. Okay, so and priority of wages during recession, many employers being declared bankrupt. Therefore, employees are left empty-handed as they are not secure creditors. So employees are not secure creditors. Yeah, the secure creditors are the banks who gave loan to the company and so forth. Therefore, okay, there is, okay, there the amendment made in 2012 is, okay, employees can claim a maximum 4 months wages. Okay, however, okay, there is okay, 4 months wages only. So let's say if the company owes the employee more than 4 months, but employee, okay, can only claim up to 4 months only. This is quite rampant in the during economic downturn. Let's say the salary is 1,800, but the company cannot pay, so the company only pay half every month. So the employee consented to that, consented to because otherwise let's say if they do not consent, what happened if the company went bankrupt? So they will get nothing at all. So the employer call all the employees and say that we are now facing difficulties. We can only pay you half of of your salary. Okay, so up to the employee whether they want to accept it or not. Okay, if the employees I've witnessed this situation in one company. So the employee accepted that the company pays them half pay and the rest is considered as the company owing to them. Okay, so let's say, okay, it's been going on for 1 year. Okay, so 1 year, so the company owes quite a lot of money to the employees. Then the company, okay, apart from that, the company cannot pay at all. So, okay, so let's say 9,900 ringgit a month. Okay, times 12 is already 108. Okay, am I right? Yeah. So meaning that, okay, so his salary is 1,008 per month. 1,008 per month is is 7,200 only. Okay, so meaning that the company is allowed to pay him up to 4 months salary. So 10,800 minus if you were to minus 7,200, so meaning that the company this is what we call as if this is non-performing loan. Okay, you don't have to pay anymore. Okay, so meaning that the amount of 3,600 the company will be in a way forfeited because the company cannot pay anymore. In Malay, you halalkan saja. Okay. Okay, now I'll stop here because for this one there will be a lengthy explanation. Okay, so this one will be in our third video. Okay, so what we did today in this video, I've briefed you the statutes, I've briefed you the terms like contract of service, contract for service, and I've explained to you the nature of termination. Okay, what do you have to do if you want to leave your company? And for the employer, they must give justifiable ground, and I've already explained to you when it comes to wages, what is wages, how it can be paid, and so forth. So that's it for now. I will continue later. Thank you.